Welcome to Coffee with Dan. This morning, we are going to discuss another interesting topic. Actually, in our society, we are talking about law and justice. And another concern in this relation is the law's delays. How the law delays or how the justice delay. I have with me today Mr. Saliya Pieris, President's Counsel, to discuss about this topic. He's a member of the Human Rights Commission of Sri Lanka. He holds a master's degree in international business law from the University of London and a bachelor's of law degree from the Open University of Sri Lanka. Between 2015 and 2017, he was the Deputy President of the Bar Association of Sri Lanka. He is also an Eisenhower Fellow and he's the Chairman of CFPS Law School. Good morning and welcome to the studio, Saliya.
Good morning, Dave.
To open our discussion, how do laws delays affect the administration of justice?
Well, I think laws delays affect the administration of justice very much because twofold. If you take, for instance, criminal cases, when it takes a long time to deal with a criminal matter and to decide on the guilt or the innocence of an accused, on one hand, the victim is prejudiced because the victim, who is victimized by crime, has to wait years, sometimes decades, before justice is meted out. On the other hand, from the perspective of the accused, an innocent accused who has to continue, if the accused is innocent, then he has to go through the agony of a protracted criminal trial for maybe decades, which would affect his family, so on. Even guilty accused. Now, if we find cases where people have committed a crime, then they come out on bail. Then they move on in life. Sometimes when they are in their 20s when they commit the crime. They move on in life, they get married, they have children. Then about 10 years, 15 years later, suddenly they are found guilty and punished, sometimes sent to jail. Now that affects not only the accused, but then his family, his children. Now, so this is the one aspect of laws delays. As a whole, I think the society is affected because then when administration of justice is delayed, there is an issue. In civil cases, sometimes we know that sometimes land cases take years or decades to complete. Dan, in partition cases, for instance, I have come across partition cases where the final appeal was dealt with 40 years after the institution of the action. Now, sometimes generations have passed and it is the second or third generation which ultimately gets the fruits of their lawsuit. So I think that is the problem with the laws delays, that it fundamentally affects the society, it affects the administration of justice, and then people lose faith in the system. If people feel that they cannot get justice in time, then if you have a land matter, if you want to get your tenant out legitimately, you go for a case, it takes years to decide what happens, then you might see, well, it's not worth going to court. It may be better for me to look for some extrajudicial means to get the tenant out. So these are the drawbacks of laws delays.
Even though lawyers talk about laws delays, there is a popular perception among the general public that lawyers are responsible for laws delays. What do you have to say to that?
I don't think we can single out one sector for being solely responsible for laws delays. I think it is a number of factors. Certainly, the legal profession also has its share of responsibility for laws delays. I'm not saying no. But it is not only the legal profession. I think there are a host of factors. For instance, we know there is a lot of long delay on the part of the authorities. For instance, in criminal cases, you find the police take a long time sometimes to institute proceedings, to file plain, to file documents. Sometimes productions take a long time to be sent to the government analyst. We have a problem in Sri Lanka now. From all over the country, productions come to the government analyst in Colombo. I think the analyst has one regional office out of Colombo, but other than that, there aren't regional officers. So everything is concentrated in Colombo. Then there's a long delay. For instance, in heroin cases, for the analyst report to come, back to court, it takes time. In cases such as weapons, offensive weapons, bombs, the reports take time to come. So there is a backlog there. Then again, there is a backlog sometimes in the Attorney General's department for numerous reasons. It might be due to lack of staff, pressure of work. Of course, it is also due to responsibility of individuals. Then within the judicial system, there is also a delay. Now, once again, that there are numerous factors which contribute to this. The lack of courts. Now, for instance, we know that in the Supreme Court, there are, including His Lordship the Chief Justice, there are 11 judges. Now, the number, if you take daily, if you take the number of cases, it is physically impossible for any judge to handle that number of cases which are heard daily in the Supreme Court. So then, unless you increase the number of judges, unless you change the procedures, you're going to have laws delays. So I think one of the main factors in laws delays are the protracted procedures in court. And for that, the law needs to be amended. The law needs to be amended. The new procedures have to be introduced. And maybe you have to also introduce time frames. Because otherwise what happens, sometimes the litigants come into court, they spend the day in court, then they have to go out of court, finding their case is postponed. So maybe it is time to think of introducing time frames and time slots. And there are examples we can draw from other countries. So the answer to your question, it is not only lawyers who are responsible for delays, it's the number of sectors, a number of factors which contribute to laws delays in Sri Lanka.
Now, whatever the causes or whatever the root causes are associated in these laws delays, as you correctly said, end of the day, it's the litigants that suffer. So what are the best ways to erase laws delays in your opinion?
Yeah, I think there are several factors. One thing, I believe that the procedure there has to be addressed. Protracted procedures, you have to look at new ways. So for instance, now we have this year, Parliament passed an amendment to the Civil Procedure Code, where they are attempting to introduce something called pre-trial hearings in civil cases. So the aim is to cut short the actual trial and to sit down with parties and agree, where the parties will agree these are the issues, and so these are the time frames within which we can resolve the judge can dispose of. So for instance, pre-trial is one example. But in similar way, I think even in the Criminal Procedure Code, amendments need to be carried out. You have to look at the processes, look at the procedures, and amend those procedures to cut short. For instance, to give you an example, in the appellate courts, especially in writ applications, one reason, and in fundamental rights cases, one reason for cases to get postponed is there is sometimes when an official against whom a case is filed in name, the official changes, you have to substitute the new person. Now that again gets postponed. Now for instance, the Public Service Commission, if you institute action against the Public Service Commission, each time the Public Service Commission changes, you have to amend the caption. Now that takes unnecessary delay. But a simple amendment to the rules enabling a case to continue in the original names will help in cutting short the short delays. So I think one single most important factor is the processes. Secondly, I think judicial management. I think it is my belief that both lawyers and judges training has to go beyond training in the law. I think you have to introduce management, administration into judicial and legal training so that lawyers and judges are trained to manage. Because we have seen sometimes judges who are good at administration. There are judges who are very good at management. They manage their trial role. They might have a heavy workload, but they manage their cases. So I think part of the art of dealing with cases and in time is the ability to manage the role in court. And for that reason, I think judges also have to be, and lawyers of course, have to be trained in areas such as administration, management, so on. That is the second aspect. The third aspect is you have to look at government institutions where delays occur. For instance, the analyst department. You have to increase the resources. You might have to decentralize. Now, for instance, if a barrel of illicit liquor is discovered, is found in Anuradhapura. And if the accused wishes to contest the case, that illicit liquor has to be sent to Colombo for analysis. Or we'll say few milligrams of ganja is found in the possession of a person and he contests it, that sample has to be sent to Colombo. So we have to think of whether there is a possibility of decentralizing these institutions. Have several laboratories throughout the country under the government analyst, so that then the reports could be quicker. On the police, I think require training and a focus on how to alleviate delays, because we find that is also another aspect where there are delays on the part of the government officials, including the police. So once again, that is also another aspect of reform. Then where the legal profession is concerned, I think the legal profession also has to take cognizance of the fact that laws delays is actually detrimental to the legal profession. My view is that if laws delays are alleviated, if the laws delays are reduced, people will have greater faith in the system. Lawyers will find they have more cases to handle, because when people have faith in the system, they will come into the system. Now, very often today, people are reluctant to institute action, even a civil case, because they know that they have to spend a long time before getting a result. So then some people will say, oh, let's forget it. But if you have faith in the system, if the system is expeditious, more people will come into the system. So these are some of the areas, I think, which require reform. And of course, as I said, this is of course my view. I know that there are many people in our profession who would not share this view. I think there must be time limits to submissions in court. Then an example, in the United States, in the Supreme Court of the United States, a party is given a limited time to make submissions. And where there is a light which lights up, a green light, and then when your time is up, a red light comes and you have to stop. Even halfway through, you have to stop. So then you manage your submissions. Now here, unfortunately, sometimes we find people make lengthy submissions, hours on end. They make submissions, and as a result, other cases get postponed. I think you must introduce time slots, limits to time limits in respect of submissions, of course giving the court a discretion in a fit case to allow counsel to make longer submissions. So in this way, I think, and of course the other aspect is to increase the resources where the courts are concerned. You have to increase the number of courtrooms, increase the number of judges from the lowest court to the highest court. That has to be increased, and so that the workload is shared. And also, I think you have to look at the whole system. Now, for instance, today, a lot of what we call the civil appeals from the civil appellate high courts come into the Supreme Court, and the Supreme Court has got clogged up. So whether there should be a system where the Court of Appeal sits in the provinces is something I think we have to look at, to increase the number of Court of Appeal judges. In fact, I think the Bar Association had made that proposal during the constitutional amendment to increase the number of judges and to have the Court of Appeal sit outside Colombo also. And so that then cases can be expeditiously disposed.
Well, I also hold the view that we need to increase the resources. And comparing to the yesteryears, we see that more lawyers are taking oaths every year. Like I heard this year in December, there are about 800 lawyers coming out taking their oaths as attorneys at law. So do you also see that we need more lawyers in the profession?
Well, my view on the number of entrants to the legal profession is that what we have to do is increase opportunities to young lawyers. Of course, you must ensure that those who enter the legal profession, you must ensure that there is quality. Those who qualify from whatever way, whether it is from law college, the law faculty, the state universities, or the certain foreign LLB degrees. I think it's very important to ensure quality and have a system of quality assurance. That is one aspect. But similarly, I think those who pass out we must look at new opportunities for the legal profession. For instance, Dan, an example is the very few lawyers are involved in tax work. Today, almost the tax work is entirely handled by accountants or other professionals. Very few tax matters are handled by lawyers. But that is an aspect which can be encouraged. So I think the idea is for new lawyers who pass out, we must build new avenues for them to go on. Now we know that there are the BPOs, for instance, and which help young lawyers to enter the system. We must increase that. I think the number of courthouses have to be increased. Although it might not be popular with everyone, but still I think because I believe that ultimately litigation has to be focused on the litigant, and the benefit of the litigation is there for the primary benefit of the litigant, and that we have to keep in mind.
Today we are discussing about loss delays, which is a very important topic in this country. And I have with me Mr. Saliya Pieris, President's Counsel, who is a member of the Human Rights Commission of Sri Lanka. He holds a master's degree in international business law from University of London, a Bachelor of Laws degree from Open University of Sri Lanka. He was also a Deputy President of the Bar Association of Sri Lanka. He is also the chairman of CFPS Law School. And getting back to our discussion, Saliya, what are your views on the importance of legal profession in our society?
Well, I think the legal profession is a very important profession for the society, sometimes not always appreciated by very many in society, but I think the legal profession is a very important aspect, especially for those who want to maintain the rule of law in our country. So if you look at the legal profession all over the world, there has been a massive contribution to the development of the society. And if you look at even whether it's independence struggle of Sri Lanka or in India or in South Africa, you find lawyers have been at the forefront. So I think the legal profession has a duty towards the society, and the legal profession is very much relevant to the development and preserving the society and preserving the rule of law, democracy, human rights in a country.
And I asked you before that the general perception of the public is that the lawyers are even responsible for loss delays. But so what should be done to improve the public image of the legal profession?
Yes, of course, we must confess that the public image, not only in Sri Lanka but all over the world, of lawyers is not, shall we say, not always high. There is this famous story, they say, the French philosopher Voltaire, that when he was dying, there was a lawyer on one side and a priest on the other. Now Voltaire was from a Christian country, so they say that on his deathbed, when he prayed, the lawyer on one side, the priest on the other, he said he had prayed and said, "Lord, like you, I'm dying between two thieves." So that is the public perception sometimes of the legal profession. So I think to improve the image of the legal profession, I think we must one thing is we must make the public aware of our contribution to the society. Over the years, I think for instance, the Bar Association of Sri Lanka has played a very important role in Sri Lanka. Role of lawyers, I think, has to be highlighted. Of course, also, I think it's important for lawyers when you're dealing with the public, dealing with your clients, to portray that positive image. And for that reason, I think our entire system must now try to be oriented towards the litigant, to be litigant friendly. And I think on the part of the legal profession also, there is a duty towards our clients, to be frank with our clients, to be honest with the client, to keep the client abreast of what is happening in his case, in his or her case, to make them feel that, that sometimes not only lawyers but professionals sometimes have this air of superiority over their client or customer or patient. Now, I think that has to change, and there has to be an era where the client is recognized, given due recognition and due respect. I think that is very important to improve the image of the legal profession. And from the point of view of the litigant, I think if the courts, if our system is more litigant friendly, that will enhance the image of the profession and the judicial system, legal system as a whole. For instance, then one of the things which I sometimes feel is when a litigant comes to court, what facilities are litigants offered? If you look at most of our court, what facilities do litigants have? If a mother who is feeding her baby, is there a facility for mothers who come into court? What about the canteen facilities, the washroom facilities in the courtrooms for litigants? If a litigant comes, is there an information desk for where they can get information about their case? I think there are a lot of things we have to make our system litigant friendly. And I think it's also very important in the courtroom that witnesses, accused, witnesses, victims, that they are treated with respect. Very often we see different sectors, segments not treating witnesses, litigants with due respect. I think even an accused has a right to be respected. He can be dealt with, he can be punished for his crime, but he has a right to be, every person who comes to court has a right to be respected. And I think that we have to build upon that. If so, I think the legal system, the legal profession will have more respect from the people of this country.
You mentioned the fact, Saliya, that the legal education in our country has to go into new vistas. And you being the chairman of CFPS Law School, what are your now there are also some private institutions that are coming up. Various international universities are offering LLB degrees in Sri Lanka. What are your views on legal education in Sri Lanka?
Yeah, well, I think legal education in Sri Lanka, I believe has to change. One aspect which I think requires change is that, as I mentioned earlier, that from mere teaching of legal and procedural subjects, I think both at law college and universities, you must look at new areas. So the areas I can identify, for instance, business, management, sociology, psychology. Those are some subjects which must be taught together with the law. Now, I am aware that sometimes in certain foreign universities, for instance in the United Kingdom or the United States, there are subjects which help to develop the mind of law students. For instance, I know of one university, the University of Warwick, there is a subject called Shakespeare and the Law, where students are taken through 2 or 3 of Shakespeare's plays, and they try to focus on the relevance of those plays to the law and to the society. Now, in similar way, many universities have a variety of subjects which they offer: climate law, medical law, so on. So I think in our system we teach very much in the same old way. So for instance, take Sri Lanka Law College, a criminal law, we still teach essentially the penal code. But today, you have the bribery laws, the laws relating to narcotics, money laundering. So I think there has to be a change both in the syllabuses and in the subjects and in the way you teach, where you bring in even subjects from outside, which are strictly maybe not law related subjects, but which would help a student to develop an overall knowledge of the law and help the student to apply the law to society.
For years, there is a perception in our society that the system helps the accused to go free. And with the recent incidents that have happened in Sri Lanka, people still think that the law is not strong enough. What do you have to say about that?
Well, what I wish to say is, we must always keep in mind that there has to be a fair trial to an accused. Not only to an accused really, but to a victim or everyone, there must be a fair trial. And we must know that while there are guilty accused, there are also people who are innocently accused of crime. So you must always ensure that there is justice done, because justice means punishing the guilty, but the justice to the victim will not be achieved by an innocent man being convicted. So that is why those safeguards are there. So sometimes the public see those safeguards as the law helping to protect the guilty, but those safeguards are really there because to prevent a miscarriage of justice. And that is why our constitution guarantees the right to fair trial. And we have the presumption of innocence, which in all civilized countries they have. So I think those are very important safeguards which are there. And we must also understand the system, the legal system cannot find people guilty because the public want them to be found guilty. They have to be found guilty because there is evidence, according to law, not according to public perceptions. It is very dangerous if a society tries and finds people guilty and punishes them because the public want it done. That is the difference between the rule of the mob and the rule of law. So although there may be a perception that the system favors an accused, I don't think that is so. The system does not favor accused. But there have to be safeguards, because otherwise there could be a miscarriage of justice.
Saliya, what are your final thoughts on how we could improve this legal system?
Well, I think I have shared a few thoughts on how we can improve the legal system, but I think basically what is important is to build public confidence in the system, and also to ensure that the system is there to preserve democracy, to preserve the rule of law, and to safeguard human rights. I think those are very important. And ultimately you come to what, if you take our constitution, the constitution talks of, so there are certain pillars of the constitution, like fundamental rights, democracy. So those are, I think, it is important that the legal profession focus on safeguarding that.
Thank you very much, Saliya. Today in Coffee with Dan, I had Mr. Saliya Pieris, President's Counsel, to talk about the law's delays. Saliya is a President's Counsel and is a member of the Human Rights Commission of Sri Lanka. He holds a master's degree in international business law from the University of London and bachelor's of laws degree from Open University of Sri Lanka. He was also a deputy president of the Bar Association of Sri Lanka. He is an Eisenhower Fellow, also the chairman of CFPS Law School. Thank you for joining Coffee with Dan today, Saliya.
Thank you very much, Dan. Thank you.
So we will come back tomorrow.